In this part of our discussions, we'll consider the proposed EU Anti-SLAPP Directive, which was introduced by the European Commission in 2022 and is currently being considered by the legislative institutions of the European Union, namely the European Parliament and the Council of Ministers. The full name of the proposed directive is a directive of the European Parliament and of the Council on protecting persons who engage in public participation from manifestly unfounded or abusive court proceedings, and in brackets, strategic lawsuits against public participation. Immediately then we see that the directive deals with a broad definition of SLAPPs, both manifestly unfounded or claims which are not manifestly unfounded but are otherwise abusive. But there is an important distinction to be drawn between those different types of claims, as we'll see in a moment. A manifestly unfounded claim benefits from all of the anti-SLAPP remedies, whereas we'll see that claims which are not manifestly unfounded but otherwise abusive also benefit from some remedies but not the full array of remedies available. We'll come to that later in our discussion. Before we get to those remedies, we need to first consider the scope of the directive, the key definitions which must be satisfied in order for the directive to be triggered, and therefore for the remedies to be available to the respondent. And we'll then consider the remedy of early dismissal, available only in respect of manifestly unfounded claims, and other remedies which are available in respect of all types of SLAPPs. Once we've considered these remedies which will be available in the courts of the member states of the European Union under the proposed directive, we'll also consider a further problem which is addressed in the directive, which is how to deal with SLAPPs brought outside the European Union. And the proposed directive includes a chapter concerning third country judgments and the way in which the courts of the member states are to provide protections to respondents also in respect of SLAPPs brought in countries outside the European Union, and therefore there is a method to avoid bypassing the anti-SLAPP protections which will be introduced in the EU once the directive comes into force. As I said, however, we must begin by considering the scope of the proposed directive. Now, as we go forward, it's important to bear in mind that the directive is a minimum harmonization measure. So what we're discussing here are the minimum standards which must be available in the courts of all the member states of the European Union. The member states, when they transpose the directive, because of course directives require implementation in the member states will be free to adopt higher standards of protection than the minimum required by the directive. But of course we can't speculate at this stage as to what the member states will do in addition to the minimum which they must do should the directive be adopted in its current form. So what we will focus on is what is currently being proposed. Now, the scope of the directive is restricted to matters of a civil or commercial nature with cross-border implications. We then need to divide those terms into two key points. First, matters of a civil or commercial nature. What this means then is that the directive does not address SLAPPs through the criminal law, and nor does it address acts or omissions of the state, acta iure imperi. What it does address is all civil or commercial claims. So it isn't restricted to a particular type of civil claim such as defamation. The drafting of the directive acknowledges the fact that SLAPPs come in many forms and that they could include defamation claims, but of course they could also include intellectual property claims, they could include privacy claims, and so on and so forth. So it is all matters of a civil or commercial nature which are covered, provided, however, they satisfy the next requirement, which is that they have cross-border implications. We then must understand, we must define cross-border implications in order for the directive to be available. Now, the definition of cross-border implications in Article 4.2 begins in a particularly conservative manner. It uses terminology which is familiar to private international lawyers, essentially a reference to the domicile of the parties, a reference to where the parties live, and of course with that domicile is considered with reference to the relevant court. So if both parties are domiciled in the same member state, and if the claim is brought in the member state in which the parties are domiciled, then the matter does not have cross-border implications under this part of the definition. So, for example, if a claim is brought in a Slovenian court and both parties are domiciled, both parties live in Slovenia, then under this definition, the claim does not have cross-border implications. However, the definition then is extended, is broadened to account for the fact that cross-border implications, particularly in a system of governance such as that of the European Union, could be apparent also in circumstances such as, for example, where the matter of public interest being considered in the court proceedings is relevant to more than one member state. And of course, given the nature of the internal market, in which economic activity often has cross-border implications because businesses engage in cross-border trade, they provide their services on a cross-border basis, because public life operates on a cross-border basis also in the political sphere. In that case, then, the matter could have cross-border implications even if the parties all are domiciled in the member state of the court in which the claim is being heard. In addition to that, the scope of the directive in respect of cross-border implications is also broadened with reference to the possibility that proceedings are brought in multiple member states. And of course, if proceedings are brought in multiple member states, either by the claimant or by related parties, that would suggest then that the judicial process is one of cross-border interest, and therefore that the definition of cross-border implications is satisfied. So again, we begin with that narrow definition of cross-border implications with reference to the domicile of the parties. However, that is extended through this innovation in the directive, which notes the fact that cross-border implications could be apparent also if the matter of public interest extends to more than one member state, or indeed if claims are brought in multiple member states. We must move on, however, also to consider what we mean by SLAPPs, because of course these remedies are only available in respect of what can properly be considered to be SLAPPs. You'll see on this slide, perhaps to your surprise, that the terminology we're using here, however, is not strategic lawsuits against public participation. The Commission chose terminology which is more familiar to lawyers in the legal systems of the European Union, and refers instead to abusive court proceedings against public participation. So the term SLAPP is to be seen in the title of the directive, it's to be seen in the preamble of the directive, but in the substantive provisions we refer to abusive court proceedings against public participation. And of course, that requires us to identify what is meant by abusive court proceedings, and we'll see on the next slide also what is meant by public participation. So we begin with that notion of abuse. What are abusive court proceedings for the purposes of the directive? Well, the directive defines abusive court proceedings as proceedings which are fully or partially unfounded. So the claim need not be entirely unfounded to be abusive, but we'll see later when we consider remedies that there is a distinction between those fully or partially unfounded claims. So a claim which is either fully or partially unfounded and has as its main purpose the prevention, restriction or penalization of public participation is an abusive court proceeding against public participation, or a SLAPP in the discourse with which we've become more accustomed. We then need to consider, of course, how do we identify that abuse. So it's not only the unfoundedness of the proceedings, but also that element of abuse which we need to identify. And the directive helpfully provides some indicators of what could be indications of that purpose to prevent, restrict or penalise public participation. Now that could include disproportionate, excessive or unreasonable claims. It could include the initiation of multiple proceedings by the claimant or related parties in relation to the same thing. So why bring multiple claims when you can bring one? It could include other elements of intimidation, harassment or threats on the part of the claimant or their representatives. If these elements are present and the claim is fully or partially unfounded, then it could be a SLAPP or abusive court proceedings against public participation as the terminology in the directive has been developed. But of course, again, we must make sure that not only do we show that this is abusive, that the claim is abusive, but that it relates to public participation. So what then is public participation? How is it defined in the proposed directive? Well, the language of the directive here benefits from the case law of the European Court of Human Rights and develops a broad definition of public participation which refers to any statement or activity by a natural or legal person exercised or carried out in the exercise of their right to freedom of expression and information. Crucially, this must be on a matter of public interest. So of course we see that distinction between matters which are purely private, which are subject to protections because of course the private sphere remains protected by human rights law in Europe, and matters which are of public interest where the level of scrutiny which is available to the public is of course higher. So public participation refers to this broad definition of statements or activities by legal persons, including preparatory, supporting or assisting action directly linked thereto, and then we have a number of examples. Of course, there is, as you can see on this slide, a requirement also, however, to understand what is public interest. So it's public participation, so it's exercise of freedom of expression, but of course freedom of expression in relation to matters of public interest. And then, therefore, we must consider what do we mean by public interest. Again, we have a broad definition which relies again on the development of our understanding of this term in the European Court of Human Rights, and essentially refers to matters which affect the public to the extent that they may legitimately take an interest in it. So any matter in which the public may legitimately take an interest. And then we have a list of examples: public health, climate, activities of persons in the public eye or of public interest, matters under public consideration. Broad definitions again, with the benefit of a list of examples. That is not an exhaustive list. So then, if we can show that the matter we are dealing with satisfies all of the definitions we've seen. It is a civil or commercial matter, with cross-border implications, and with that broad definition of cross-border implications we saw earlier. A civil or commercial matter with cross-border implications relating to public participation in the public interest, and if there are those elements of abuse which we've identified, then the remedies in the directive are available to the respondent. What then are those remedies? Well, you'll recall that I've been distinguishing at several points in this discussion between manifestly unfounded claims and other types of claims. In the current draft of the directive, the remedy of early dismissal is available only in respect of manifestly unfounded proceedings. So this is subject to some criticism by NGOs, by scholars, by members of the European Parliament, insofar as it is suggested that the remedy of early dismissal should be available in respect of all SLAPPs, not just manifestly unfounded claims. However, here we're dealing with what is in the current draft, and in the current draft, manifestly unfounded claims must be subject to an early decision to dismiss by the courts of the member state. So if a claim is manifestly unfounded, first of all, the courts must stay the main proceedings, they must stop hearing the main claim, and they must then move on to an accelerated procedure to dismiss the claim, to dismiss the SLAPP, and essentially then to cut short the time in which the respondent is subjected to those abusive proceedings. In those anti-SLAPP considerations, it is for the claimant to show that their claim is not manifestly unfounded. So if A brings a claim against B in defamation, for example, and B says that the claim is a SLAPP, they can then ask the court to dismiss the case if it is manifestly unfounded. It is in that case for A, the person who brought the original proceedings, to show that the claim is not manifestly unfounded. So we have a reversal of the burden of proof. It is for the claimant to show that the claim is not manifestly unfounded and therefore should not be dismissed at an early stage. Now, this is a very important remedy. It is one of the key remedies in anti-SLAPP legislation, but of course bear in mind it is only available in respect of manifestly unfounded claims. So the accelerated procedure, an early dismissal with the benefit of the reversal of the burden of proof, is only available in respect of manifestly unfounded claims. There are, however, other remedies available also in respect of other abusive claims which are partly founded and therefore may proceed to a full hearing. Those other remedies, available regardless of whether the claim is manifestly unfounded or only partly unfounded, include first of all that the SLAPP claimant would bear all the costs of proceedings, and that includes not only the formal costs attributed by in the judicial part of proceedings. So it's not only the costs as defined in the law, it is also the full cost of legal representation which the respondent has incurred, and that of course can often be higher than what courts would ordinarily award. So the full cost of legal representation would be covered by the SLAPP claimant. Not only would they cover the full cost, but they would be liable for damages to the respondent. So not only are they paying for the respondent's legal representation, but they must pay damages to the respondent for by way of compensation for the fact that the SLAPP was brought in the first place. So the SLAPP claimant, rather than vexing the respondent, ultimately ends up paying them. And not only is there the possibility of damages paid to the respondent. But of course, we must recall that with SLAPPs, what we're dealing with is the misuse of courts, the misuse of a public service, the misuse of the judicial process. So not only would damages be payable to the respondent, but the courts could also impose effective, proportionate and dissuasive penalties on the party who brought the proceedings. So those penalties should be enough to put the respondent off bringing SLAPPs again. So all SLAPPs benefit from these three remedies: the full payment of costs, the payment of damages, and the payment of penalties to the state. And that, of course, is important insofar as it should dissuade the claimant from bringing SLAPPs in the first place. The remedy of early dismissal, however, in the current draft of the directive is only available in respect of manifestly unfounded claims. Now, these remedies are all very important because ultimately the purpose is to dissuade SLAPP claimants from bringing claims in the courts of the member states of the European Union. But you'll note that this leaves a gap, which is, well, how do we deal with claims brought in states outside the European Union? The European Union obviously legislates for the 27 member states of the EU. What if a claim is brought instead in a country which is not, or which is no longer, a member of the European Union? Can the courts of the member states do anything to help a SLAPP respondent in that case? Well, the short answer is yes. The directive provides in Article 7, first of all, that recognition and enforcement of a SLAPP brought in a third country must be refused as manifestly contrary to public policy. So the courts of the member states cannot enforce a SLAPP judgment from the courts of a state outside the European Union. And not only must they not enforce the judgment, but the SLAPP victim may seek compensation. So they can seek compensation in the form of damages and costs in the same way as if the claim had been brought in the courts of the member states. So some of those remedies we saw earlier are obviously not going to be available in the same way in respect of judgments from third countries, because obviously the European Union can't force countries outside the European Union to legislate in a particular way. But the courts in which the SLAPP victims live, the courts in which they're domiciled, will be able to give them compensation under Article 18 of the proposed directive. And that, of course, means that we have a significant system of protection available to SLAPP respondents. We've seen in our discussion that obviously that would need to satisfy the key definitions. We need to show that the claims, whether they're brought in the courts of a member state or a third country, relate to civil or commercial matters. We need to show that the matter has cross-border implications. We need to show that that the claim is abusive. We need to show that it relates to public participation and is intended to suppress public participation. Public participation, of course, on matters of public interest. Well, if all those definitions are satisfied, we then have the remedies available, both in respect of proceedings brought in the courts of the member state and by way of compensation also in respect of proceedings brought in third countries. Thank you.